Hi everyone, welcome to an hour with LawSikho Saturday version. Today we have with us Shivam Singh from Chamber 28, and he's going to tell us today about practicing uh, criminal law at the Supreme Court on the Appellate side, and tell us about the whole experience. It's everybody's dream at some level to work someday at the Supreme Court on high-profile criminal cases, and this is what Shivam does, apart from other things, of course. We would like to hear from him today about those who are only yesterday we talked about criminal law as a profession, but that was more about the trial court experiences. Today, Shivam will tell us about the other side of criminal law practice. Shivam, very welcome to an hour with Law Secure. And why don't you tell us a little bit about yourself, your background in law, and what you have been doing all these years?
Manoj, thank you for that warm introduction, and my apologies to everybody. We started a little bit late. This was predominantly due to my fault and due to some internet issues. But having said that, let's move on. Much about myself. You already indicated it. I'm a 2010 graduate. I finished law and I read law at NLS Bangalore, after which I worked for a couple of years at the Patna High Court as a state lawyer with the Advocate General. After which, for a couple of years, I was studying abroad. I first did my LM at Columbia, and then I did a research fellowship in sports law at Harvard. And in 2014, I got back to India. Since my return to India, I've been practicing in the Delhi courts and across all forums with a firm focus on the Supreme Court. A large part of my work docket is dealing with criminal litigation, especially at the Supreme Court, and I'm thankful to Ramanuj for this opportunity to interact with a whole lot of you. It's indeed a great pleasure to be here and to be speaking with all of you.
Great. So, Shivam, can you tell us when we are studying at the law school Bangalore, uh, the idea is that you are going to probably work in a law firm somewhere. That's the general perception that people have when they go to a national law university. Although we have heard that when it was started, the vision was different and it was supposed to become a university where to create social engineers and practitioners. Uh, but what is it really like to study at National Law School of India University in Bangalore? And do you think like your college in a way prepared you for practice? And what was it really like?
So, in 2018, I've spent years outside of law school than I spent graduated then. So, a little bit hazy on what exactly the experience was like. But having said that, I would still count NLS Bangalore as 5 of my best years of life, because for me, at a very personal level, it was my first experience staying away from home and living by myself. And hostel experience, which is an integral part of any national law university upbringing, especially Bangalore, is something I remember very, very fondly. The second thing about NLS Bangalore was that, as much as the legacy of the institution stand out, it's the peer learning which really takes you to another level. And peer learning is something which I'm deeply grateful for, because a lot of my doubts were cleared by my peers and not necessarily the teachers. And a large part of the realization at a university such as NLS Bangalore was that profession as well as life is not a zero sum game. Everyone can prosper at the same time. And it is not that if one person prospers, the necessary fallout is that the other person will lag behind. So, to that extent, I'm extremely grateful for it. Coming to your specific query on the initial purpose of national law universities and social engineers, I think that particularly had a context attached to it, wherein this was a bold experiment of moving away from 3+3 system into an integrated 5 year system. And the idea was to enrich the bar by producing persons who would stand out. I still subscribe to that ideal. I think it's an extremely noble ideal, but at the same time, I feel it's slightly improper for us to look down upon people who are at law firms, because they too are doing fantastic duties and they too are enriching the jurisprudence of the country. For instance, a law firm person who is working on cutting edge legal deals is probably adding more value to the legal system than someone who is a mediocre litigator, or for that matter, even an excellent litigator. So, this discourse within the national law universities that law firms and people who go there do not necessarily contribute in a substantial manner to the legal system is something which I'm at variance with, and I don't completely subscribe to it.
No, I completely agree with you. I was not suggesting in any way that those who are working at law firms are not contributing, but I was asking that from a perspective of somebody who wants to be a criminal lawyer in the future, or somebody who wants to even litigate. Is it like, how is the university supportive? Of course, we know National Law School Bangalore for producing some of the best corporate lawyers today. We don't hear as much about litigators being produced by National Law School Bangalore. From that perspective, we just wanted to know from your experience, how do you see, like, a basic question that we often face from young law students who are trying to decide what they want to do in life is that, should I go for a national law university if I want to practice in Bombay or Delhi and work at the court? Because if I stay back, like, one advantage of, say, studying at GLC Bombay or some other Bombay law college, or for that matter CLC, is that you can continue doing some internships, continue maybe assisting a lawyer, and while you are studying, because 5 years is a long time. So do you think from that perspective, how does National Law School Bangalore enrich somebody who wants to be a criminal lawyer?
I think there are advantages NLS or NLU education would bring to the table, especially in criminal law. I agree with you that to a certain extent, the achievements or the kind of work which is done by NLU graduates in the criminal litigation sphere is not as highlighted or not as well documented as it is in, say, some of the corporate deals. But that is due to the feature of criminal litigation, especially being a area which is more word of mouth publicity as opposed to corporate deals which are necessarily well documented. Having said that, I think some NLU litigators are doing absolutely fantastic in this criminal litigation sphere. For instance, if anyone is familiar with the Delhi trial court system, and if a dispute arises on the criminal litigation side, then the go-to name is, I'm proud to say, a NLS Bangalore graduate, Mr. Siddharth Agarwal, and he's adding a lot of value to the system. For instance, even in the Supreme Court, there are NLU graduates who are doing extremely well on the criminal litigation side. One of the persons who was a young amicus at the time of the Ajmal Kasab murder case, which came to the Supreme Court and was assisting Mr. Raju Ramchandran, happened to be an NLS graduate, Gaurav Agarwal. So there are names which are doing the rounds, but it's not as well documented as it is in the criminal, or sorry, in the corporate law circle. Having said that, I believe that, and I alluded to it earlier, that a NLU legal education has distinct advantages to it. One of the major benefits from it is that it will help you in analyzing a problem in a perspective which some of the more traditional law colleges may not be able to equip you with. I'm not for a moment suggesting that some of the traditional law colleges are lagging behind in it. It's just a feature of the teaching which has become so ingrained in the NLU systems, and the fact that now the alumni are people who these colleges can look up to, that has resulted in a lot of these practices getting internalized within the NLU sphere. Having said that, one of the major drawbacks within this is that sometimes I feel, at least from my personal experience, the time when you get out of an NLU, you really feel that you're the cat's whiskers and nobody else is entitled to know anything else more than what you already know. So that is a sense of entitlement, which as soon as you can rid out of your system, the more successful you're going to be. It took me a while I moved to Patna High Court, wherein I felt that it was only I who knew everything and the rest were just fillers. And once I was able to completely rid myself out of this so-called entitlement bias, I thought that my learning was extremely superior.
Great. So, at what point did you decide that you are going to practice criminal law? Was this in college, or did the conviction come much later?
So I decided that I want to do litigation sometime in my fourth or close to fifth year. And being a third generation litigator, I had the benefit or the privilege, I can now candidly admit, of conferring with my father on this. And it was his suggestion to go to a slightly smaller court and work there. Once I moved to the Patna High Court and work started flowing, it was only then did I get to handle a substantial amount of criminal work. And a large part of your specialization also depends largely on your home court or your feeder court. So, for instance, you could be excellent at a branch of law, but if you're not getting those briefs to argue or those briefs to prepare, then that specialization in some manner of time or some matter of time tends to dilute. I'm fortunate enough that criminal law is something which is extremely proficient and extremely well developed within the Patna High Court, and those are the briefs which I have gotten largely to argue. So, to that extent, I think your specialization are a feature of the briefs that you receive. So it's not a hard and fast rule that or a hard and fast formula that I had in mind that I would practice criminal law. It was more out of the uh, the particular work docket of my parent high court that these briefs started coming to me.
So essentially, it was like you started practicing with an open mind that you would be practicing whatever matter that comes to you. But how did it go in the initial 2-3 years when you were in Patna High Court? So you graduated and straight away joined Patna High Court, right?
So I was there in the Patna High Court for 2 years. I graduated in 2010 and I joined the Patna High Court immediately. It was an extremely enriching experience because the Patna High Court is one of the oldest high courts in the country. It's now gotten a history of over 100 years. So I went there and I went there with an open mind that whatever work comes my way, I will do that. There were people along the way who encouraged me tremendously, who reposed faith, and a large part of the learning experience was that in the first few years, I never said no to a brief. If I would get a brief in late at night and the matter was next day, I would do it. If I would get a brief early in the morning and the matter was as soon as the court convenes, I would do it. So these were things which sort of encouraged me and sort of were building blocks of my Patna High Court litigation, because once people had this faith that I would take up a brief and I would not neglect it merely because it is not my own brief, then the work started coming in my way.
So a major part of getting work is how other lawyers view you and how they are considering your expertise. So how did it work out for you in the initial years? You described a bit that how you have been very eager to take anything that comes your way, didn't say no to anything. But if you could elaborate a little more about this, or I'm asking this from a perspective of a young lawyer who's trying to find their way in the court. How does it work, and what would be your advice to such young lawyers from this perspective?
Absolutely, absolutely. I'll begin this by quoting one of the best pieces of advice which I received at the bar, and I think consciously as well as subconsciously it has affected me and it has shaped my practice at the courts to a substantial extent. The advice which I received was that when you're arguing, please don't think of it only from the point of view of the one person who is ahead of you and who's listening to you, that is the judge. Please also think of the one person who's behind you, that is your client who's listening to you, and 40 others who are also behind you, who are your co lawyers, your colleagues who are also listening to you, and your judgment is being passed by not one person who is the judge, but by three sets of persons. One, who is the judge, obviously, two, the client whose brief you're holding, and three, your colleagues. So I think that level of judgment which happens each and every appearance which you have in court keeps occurring, and it's a ever repeating exercise. So I think a large part of this judgment happens whenever you step into court, the way you address the court, how respectful you are, whether you're able to digest a negative response, whether you're able to maintain your calm when things are uh, going badly against you, whether you're able to handle a favorable order with a lot of grace, or you just start throwing tantrums and things like that. So these are certain small things which tend to make a difference. For instance, I remember when decisions were not going against me, I remember still respecting the judge despite the fact that I was in complete disagreement with their decision making process. This perhaps appealed to colleagues who entrusted me with more briefs, or this appealed to the client that even though the judge was not convinced by my arguments, I was still trying to persevere. So these are things which are an inexact science, but I would say that there is some method to the madness, because this subconscious judgment which is passed at each and every appearance is something which accumulates and determines how far you go in the profession. Having said that, I still have a huge way to go in the profession, so I wouldn't say that I've achieved anything of any great consequence at the moment.
Of course, I mean there is different levels of success at the court, and like many. I think every time you read, like for me at least, I get to read a biography of one of the great lawyers at the Supreme Court, or their autobiographies. I think the very common theme that has always been there was that you keep learning and you keep growing. I mean, practicing at the court as a lawyer is literally a profession where sky is the limit. So, but tell us a little more about what are the most moments in your practice so far, or successes and achievements in your legal career so far that you really cherish.
Well, I'd answer that at two levels. Is uh, one is a experience that I would forever cherish, is being appointed as an amicus by the Supreme Court in a murder appeal, and that appointment came my way from Justice Kalifulla and Justice Lalit, both of whom I respect tremendously. Given the fact that Justice Lalit has been or had been an excellent criminal lawyer in his own right during his term at the bar, that is an honor which I hold extremely dear to my heart. So that is the first thing I would put at the top of the pile when it comes to the things or the successes I've achieved at the bar. That is the first thing, without a doubt, I would put. The second thing is an aspect of work satisfaction that I have derived at the bar while handling criminal litigation. I would recount two instances which are extremely close to my heart. One is when I had the chance to appear for the prosecution in a gang rape and murder case. There was a girl who was a teenager and who had been gang raped by a set of four men in an extremely violent manner and had then been murdered. These persons happened to be her teachers, and the trial court had taken cognizance and issued summons against them. These persons had challenged that summoning order in the Patna High Court, and the Patna High Court had agreed with their plea and quashed the summons. So there were no effective accused in that case, and that trial had been put to closure. I appeared for the prosecution. The appeal was filed by the informant. I remember this appeal was argued before a bench of Justice Kehar and Justice Bhanumati in the Supreme Court. And the informant concluded his address. The court wasn't too convinced and they were still siding with the accused. They felt that the impugned order did not need to be interfered with, at which point of time I got about 15 minutes to address the court. I remember I had just started practice in the Supreme Court. It had been about a year or a year and a half then. And I began my address, and what the court permitted me to do was to argue in my own manner. I remember arguing for about 10 minutes on pure law, and after about 10 minutes, the case had overcome me due to its sheer emotional content which I felt, and the grave sense of injustice that I felt had occurred in this, that I closed my file and I was arguing straight out of memory. At which point of time, I remember it's only happened a few times in my career that you can actually feel that there is pin drop silence in the courtroom because everyone is listening to you. That was the first time I experienced that in the Supreme Court. And at the end of the day, we were able to secure what I felt was justice because the impugned order was set aside and these persons were committed to trial. That judgment went on to be a reported judgment. It's known by the name of Madan Razak versus State of Bihar. That is something which I hold extremely dear to my heart. So these are two achievements which I could count and I would put at the top of the pile. One, the amicus appointment, and two, arguments in Madan Razak versus State of Bihar.
When you start practicing, we generally hear from our seniors that you must begin from the trial courts and like learn how it works at that level before you go into appellate side. What is your advice regarding this?
I'm in complete agreement with that piece of advice, and I would feel that it is at some level extremely necessary because if you look at the kind of learning which happens in the trial courts, it's unparalleled because you're actually constructing a case from scratch. And appeal is only you trying to dissect as to what the court below has done wrong or what the court below has done right and could have done even more right. So if you do not know how a criminal trial works, it's extremely difficult to construct a case in appeal or to deconstruct a case in appeal. I realized it for myself. I was arguing, for that matter, in the before the bench of Justice Deepak Mishra and Justice Shivam Singh, and it was a criminal SLP. And one point of time, they inquired from me that, do you think this is something which has come out in the 313 CRPC statement? At which point of time, I had only read 313 CRPC in the statute. I had never seen how a 313 deposition or a 313 statement happens in the trial court. So I fumbled in my response, and that was the end of the matter. At which point of time, I realized that it's extremely difficult to be proficient at criminal law, especially on the appellate side, without having exposure on the trial side. And that's when I decided to take up a lot many more trial court criminal law briefs. And I'm grateful for that experience.
So is it practical to while you have a lot of work in a appellate court, especially you have been doing any work that came your way apart from criminal law? Was it really possible to do trial court work at the same time?
It's a difficult, and it's a decision eats up significant your time which you have at your disposal. For instance, I returned in 2014 summer, and I remember till about 2017 summer I was working around 6.5 days a week, because I would schedule my trial court appearances as far as possible on Saturdays, because the rest 5 days were days where all courts, including the Delhi High Court and the Supreme Court, were open, and the trial courts were also open on Saturdays. So I decided that I would schedule all my appearances in the trial courts as far as possible on Saturdays, and that's what I did. So as long as you're in a mental position to make that sacrifice, I think it is possible to do it, especially in the beginning years. Once work flows in and your work docket expands, then it becomes difficult to make those tweaks in your daily calendar. But I believe in the initial few years, it is something which is definitely doable.
So when you started practicing at Patna High Court, at what point did you decide that you mentioned this already that you had enough work coming in, but how does this transition from the High Court to the Supreme Court happen? And if you can tell us a little about that.
Certainly. So, in my instance, or in my case, the Patna High Court was always a stopgap arrangement. It was a decision which I took based on advice that I received, that I should be there for a few years so as to get the experience and flavor of working in a high court before I decided to shift cities. It's pretty clear that whenever you decide to relocate, you will have to begin from scratch. So while it is a difficult decision to make, but it's a necessary decision to make. And at the appellate stage, unless until you're known in the courts below, which in the case of the Supreme Court means that you're known in the high courts, work will not come your way. Those initial years are difficult. I would still say that I'm in that position where I'm thankful to God that there is work, but it is not that I'm overburdened with work to such an extent that I can't take up new work. So the initial years are tough. I'm still in that position, but at the same time, I'm grateful that there is enough to keep me going.
So, how should one strategize? Like, so from let's say I am a law student, fourth year or fifth year, and I'm very interested in having a career in criminal law, and eventually my goal is to practice at the Supreme Court. What's happening we see nowadays is a lot of people directly start practicing at the Supreme Court, or what we see is a lot of people who are initially maybe even working on the corporate side in a law firm. Maybe they have an education loan to pay off or whatever, and they do that, and eventually they join directly at Supreme Court, maybe working at a AOR firm or sometimes working in someone's chamber. This is a common thing that we see now. However, what would your opinion be a good strategy for somebody like me, in the sense, assuming that I'm a young lawyer or a law student and trying to get into a litigation career? What would be the right way to do? I know you went first to Patna High Court, and that was advice you received from your father as well. How do you see things happening these days, and what would be your advice to somebody who's looking to do eventually wanting to end up at the Supreme?
I would suggest that whoever the Supreme Court must have experience of a court below before they decide to venture into the Supreme Court. because Supreme Court is an extremely unforgiving place, and the Supreme Court at the end of the day is the court of final appeal. So there is an overwhelming tendency with instructing lawyers, or for that matter clients, to prefer persons with gray hair and persons with significant amount of expertise. If you begin your career in the Supreme Court, barring a few exceptions, it's almost inevitable that you will be second seat or third seat in disputes which come your way. And if you're overburdened with briefs, or briefs are overflowing from day one at the Supreme Court, well, that's great. But at the same time, you need to factor in that the judges who are so seasoned and who are so veteran at the Supreme Court, that they will ask you questions which, until and unless you've had the benefit of working in courts below, you will not be able to answer straight off the bat, unless, of course, you're a complete natural talent at the Supreme Court and you've cracked the code. So that is an exception, but I think those exceptions are few and far between. So I would strongly recommend to whoever is contemplating a career in criminal litigation, especially at the Supreme Court, to spend some years at the courts below, at least the High Court, if not the trial court, before transitioning to the Supreme Court.
So how's Delhi High Court? If could somebody start practicing? Because what also another thing we see these days is that people are doing something. If they get in the Supreme Court, at the same time they are practicing at the Delhi High Court or maybe some tribunals in Delhi. What's your thought on that? Like, is that a viable way of doing things?
I think that's an excellent mode of building your practice and gaining a lot of diverse experience. We're fortunate that Delhi provides with that avenue because it is the national capital. Delhi is the only place with district and sessions court, the High Court, as well as the Supreme Court. That's due to the feature that it's the national capital. And given the fact that there are persons who are practicing actively in Delhi, it makes a lot of sense to be practicing at these places, especially in your initial years when you can build on these experiences for your future years. So the Delhi High Court or the Delhi trial courts, or for that matter tribunals, are all excellent places where you can do your learning before you decide to move to the Supreme Court. And it's not a linear exercise or a linear path. You can keep going to the Delhi High Court and the Supreme Court. There are enough people who do that on a nearly daily basis, if not on a daily basis. So I would suggest that if you are in Delhi, then make the most of its locational advantage and take up work in as many different forums as you can get.
Okay. So one thing that I wanted to ask is that this is when people start their practice, especially first generation lawyers who do not have people to refer them work. It's notoriously that you earn notoriously less initially, and sometimes people find it difficult to pay rent, or they might have some education loans or some money to send home if they have come from a different place, and people do struggle with these things. And what would be your suggestion? Is there a way somebody who wants to go into litigation but doesn't have much family support, or has to earn their own living, what should be the way they deal with this? If you have seen in your experience, you must have many such juniors or maybe younger lawyers you see. What's your suggestion? What should those people do?
So I have experienced it, but nowhere to the extent that some of the first generation lawyers would have experienced it. I remember earning an absolute pittance at the Patna High Court, and that was not even sufficient to perhaps meet my expenses. But it's a trade-off which you have to make. In the event that you have student loans to begin with, then litigation as your first job is an extremely bold decision, and it's something which will not be sufficient to perhaps pay off your education loan unless you get a mentor senior who is extremely liberal with their initial outlay. A large part of the fact that younger lawyers receive such a pittance is due to the fact that a lot of experienced senior lawyers feel that the learning comes from the fact that you're sharing chamber space and getting to work on their briefs. I think that to a certain extent is perhaps right, but I also feel that it's something which is completely divorced from reality. For an instance, I just do not see merit in the idea that a senior lawyer would not even pay their qualified apprentices or their qualified associates salaries which are at par with minimum wages within the city. And if a senior lawyer is not willing to do that, then it just reflects you to you their way of thinking, which I'm not entirely aligned with.
Thank you for bringing that up. That how it's a big challenge, because perhaps senior lawyers are not willing to support the juniors. But if you could tell us a little more about what could, like, if somebody finds themselves in this situation, what could they possibly do? One thing what from your answer I found that maybe find those seniors who are supportive a little more compared to there are of course seniors who are not at all supportive. But apart from doing that, what else could you do?
I think there are two things which spring to mind that as a young lawyer, you should be amenable and agreeable to draft a lot, because very often there are chambers which are overburdened with work and who have very strict deliverables in terms of timelines which they are unable to meet, especially with the available resources. So they can always use additional helping hands. So, for instance, if you're amenable to draft applications and to draft small matters, then that is something which will help you in meeting a certain amount of expenses. So that is the one advice I can give immediately in the litigation sphere. The second advice, which not entirely related to litigation but equally valuable, is to take up part-time teaching appointments. These are appointments which would help you because if you're teaching law at the same time you're revisiting a lot of your first principles and your basics, and by doing so you're sharpening the saw in the proverbial sense, and that is something which will equip you in courts to be a better lawyer as well as help you make a certain amount of money on the side. So these are two pieces of advice which I can offer to younger lawyers who are contemplating a career at the bar.
I think that is really excellent suggestions. Both are, I have seen lawyers doing this, both of these things very successfully, and it really worked wonderfully for them. Also, one more thing I can add perhaps is that you could consider drafting contracts as well, because this is something which may not be directly related to the litigation practice, but it's if you know how to draft contracts, you can earn like your at least if you draft 3 4 contracts, you'd be able to pay for your rent and basic expenses in a month with without investing maybe a lot of time, which you can do. Contract drafting doesn't need you to be present somewhere, or also it introduces you to some new clients perhaps. Would you say
Sure.
that's correct?
Yes, I do. I do agree with that. It's in fact something which I did at a very limited extent, though, in my beginning years. I had the opportunity to draft contracts, something like a non-disclosure agreement or something in the nature of a service agreement or a rent agreement. These were things which I took up on the side, and it was something which did help me meet a certain amount of my financial expenses. So those were something I remember doing.
Great. So this I think in with time it is becoming easier for lawyers to get into litigation. Those initial years were really dreaded. I think 10 years back it was worse, but now you have some options to float yourself through those initial dreadful years of litigation. Besides this, what would you say are the important skills a young litigation lawyer to develop. uh, Maybe you can even go back to the college time. Like sometimes people say that I'm in college now and I'm reading my law, I'm reading my CPC, CRPC, Evidence Act, Companies Act, etc. But beyond this, what else can I do while I'm in college? Because 5 years is a long time, and sometimes people find that they have a lot of extra time. What would you suggest they can do? So this is at one level, and another level I want to ask, as we begin practicing in the court, what are the things we could do, or what are the things that we should really make an effort to learn?
I think coming to your first query as to what are things which people could do while they're at law school, it's something which personally I did not do, but I see a lot of benefit in hindsight if people were to do it, is to write very, very actively. I think a large part of it begins with blogging because once you're into the profession, you'll find that invariably you're drawing out pleadings, whether it be pleadings you file or whether it be written arguments which you prepare for your own self. Now, if you're not in the habit of writing from the time you're at law school, it's going to be an exercise which you will have to repeatedly undertake and learn on the job or learn at the job. So I think the sooner you begin, the better it is. So that is something which I would definitely recommend to younger lawyers who are still reading law if they can do that. The second thing which I would strongly suggest is the ability to research, because research is something which will make or break your career, especially in the initial years. Because, for instance, if you're getting a new client in a particular area, and if you're completely clueless about that, and you don't even know where to begin to research, then you're in a bit of a tough spot because it's going to be extremely difficult to retain that client. So you will have to continuously read and to keep sharpening up your research skills on a nearly daily basis, if not a weekly basis.
Great. So I think that's very valuable advice. So two things I got from your answer is that one is blogging and writing frequently, and I would say that writing, perhaps blogging is also better, because if you're trying to publish at a journal, then it's such a long process that you end up spending 6 months trying to publish one paper, which is not a frequency at which you should be writing. Probably if you're blogging, you can write every week also. Uh, that's one very, I think, useful advice. And the other thing you said is that we must develop our research skills. So what is the way you would suggest that a law student can actually develop a good research skill? Because we are familiar with the situation that people are one thing we knew is that doing your class projects, but I think fewer and fewer institutes are taking this class project seriously, and there's a huge plagiarism problem. And we are seeing that even professors have their PhD theses plagiarized. So the culture is against research right now. Rather, even when we have something that requires research, people are adopting shortcuts. Where do you think? So it's also not about only about an individual. If everybody is copy pasting their uh, projects, perhaps as one individual, you will not find yourself very encouraged to do original research and write and publish. So where could people get validation for their research if they're doing it right or wrong? uh, what would be the way to know that you're doing the right research for that matter? What could a law student do in that environment? What would you suggest?
I think the best way to go about research is to unlearn your experience of beginning everything with a Google search. Because I think that's something which a lot of younger lawyers, such as us, are guilty of doing. I have been guilty of doing that for a really long time during my initial years at the bar. Whenever a research proposition came my way, I would begin by just googling it and going to the first hit and then trying to figure my way out. I think that does a great disservice to your research abilities and the seriousness with which you're able to apply yourself to a problem. Because you need to remember that while at law school you're dealing with a very theoretical model of teaching, when you are a litigator at the bar, you're dealing with live persons, you're dealing with hard facts. And to then relegate your mental faculties to the powers of a internet search engine, even as powerful as Google, is something which is slightly, I would say, suboptimal to my mind. I would suggest that young lawyers need to get into the habit of reading textbooks and commentaries. For instance, I remember facing it myself. A colleague gave me a proposition on how Section 420 of the IPC needs to be interpreted to distinguish between civil wrongs and criminal offenses. And without even looking at uh, the IPC and reading the section in toto, my reaction was to just start Googling it. At which point in time, I rightly received a dressing down, and that's something which is now ingrained in me. That you first need to read the bare text or the bare act, and then you need to read commentaries, and then you need to supplement it with online research, as opposed to the other way around, which is something which a lot of us are guilty of doing.
So, once, of course, this was the first part of the question, and coming to the second part now, that when you are already have began your practice, what is it? How does it work after that? What are the things that one need to learn? What are the different skills that one need to learn? If you can tell us about that process.
I think something which law school, and for that matter, even law universities, just do not equip us with vis-a-vis litigation are small little things which make a huge difference. For instance, we are well versed in moot court etiquette of how to address a court by saying that by addressing the court as may it please this honorable court or your lordships, etc., etc. But we are not equipped to say mention a matter. We are not equipped to prepare a listing pro forma. We are not equipped to deal with the registry. These are some things which we are just not equipped to do. So I would definitely encourage young litigators, or for that matter, students in their final years at law schools, to pay a lot more attention to these things, because a large part of your learning will come from these matters, especially when you're beginning your career. So, for instance, somebody can come up to you at 10:20 in the morning and say that here is a matter which you need to mention, and I want it on board so that such and such senior lawyer can argue it tomorrow. And if you don't know how to mention a matter, then, well, that brief is not going to come back to you ever. So that is something which you need to equip yourself with. And that is something which law schools just do not teach us. I do not know why they do not teach us, but it is something, the sooner they come or become a part of the curriculum, the better it is for everybody.
So the few things I got from your answer is that how to mention matters. One is you said is how to perhaps you were saying pro forma listing, and another thing I missed out. Could you repeat that? There are three things I got. Like if you could tell us a bit more about this, elaborate a little. What are the skills that one should try to learn? Maybe even more broader heads in terms of uh, what are the knowledge and skill one has to develop to succeed at practice.
So I think there are a huge amount of skills, and no one can quantify all of them. But some of the main skills, or some of the things which you will encounter on a nearly daily basis, are how to ensure that your matters come up on board the soonest. Because at the end of the day, if your client, or for that matter, an instructing lawyer, comes to you and requests you to ensure that this matter comes up on board and is taken up on a priority basis. And if you do not know what goes into making sure that happens, you're going to lag behind. For instance, there are a few ways to do it. One of them is obviously to mention a matter in court and to prevail upon the judges that this is something which requires their immediate attention. That is something which happens nearly in all courts, depending on the court. For that matter, it could be before the senior most judge or the roster in charge. There could be a judge in charge on the criminal side. There could be a judge in charge on the civil original side. There could be an overall judge in charge who's the master of the roster in the courts concerned, which could be the High Court or for that matter, the Supreme Court. So you need to learn how to mention matters. The second thing is that if you simplify it for the judges on how to decide your cases, then that can be a huge benefit to begin with. For instance, there is a listing pro forma which is appended to a lot of matters. It's a necessity in the Supreme Court. In different high courts, the procedure varies. So if in your listing pro forma you mention or you indicate that there are similar pending matters in which interim relief or in which final relief has been granted, and if you make a mention of that in your listing pro forma and subsequently your pleadings, that makes it extremely easy for the judge to know that yes, this is not uncharted waters for them. There is a line of precedent which they can rely upon. Then that makes your job that much easier. And the third thing which I would suggest is that you just need to be a regular at the courts and be there on a daily basis, because a large part of your learning and your work will come about when you're there in the courtroom on a regular basis, because familiarity will lead to some work coming your way sooner rather than later.
Okay, so when you say if a person is practicing at the Supreme Court, uh, what are like the best days look like, and what are the worst days?
Well, the best days are those days when you have to say pretty much nothing and the court agrees with you. That happens once in a while. Uh, and the worst days, well, there are far too many. The beginning years, and even when you're slightly into the profession, the worst days, you just can't describe it. For instance, you could have one matter in which you're seeking an immediate stay or an injunction on the demolition of the house. And if you're unable to persuade the judge and your case gets thrown out of the window, then the house is demolished. You lose that case even before it's been argued in its entirety. So worst days can take many, many different forms. I would perhaps recollect my worst day as something which I now look back at it with a smile, but I know at that time I was completely deflated. I was arguing final appeals, and final appeals at the Supreme Court are generally heard at substantial length because they deal with substantial questions of law. I remember arguing it before a bench of Justice A.K. Goyal and Justice U.U. Lalit. I argued five civil appeals or five appeals, civil and criminal, within an hour, and they were all unconnected with each other and losing each and every one of them. By the time I lost my fifth appeal, even the judges were smiling and thinking that it's nothing personal. It's just one of those rough days at the office. So those things do happen, and you need to learn to take it in your stride.
All right. So we hear a lot about networking, how networking is very important for lawyers. What is your take on it, and what is your advice on this young lawyer?
I definitely see merit in that idea. Networking is important. It's a feature of human relationship building, and you can't run away from it. For instance, if you're part of the same bar, and you're always giving someone the cold shoulder, a day may come where you need that person's help in a matter which you need to get adjourned. And if you've always been extremely stiff and stern with them, then good luck seeking their consent for getting a matter adjourned. So at small levels and even at on a business development plane, networking makes a huge difference in the kind of work profile that you're able to build for yourself.
So how to do it right? I mean, every lot of people understand networking to be like just to use the word smooching, or it's like more like giving your cards to people. I mean, I don't think that's really networking. If you could share some best practices on how to do it right for young lawyers.
Sure. Well, I don't think that you can really quantify it as, say, the top five things one should do to make sure that networking is done right. I don't think it's an exact science in that matter. But there are certain things which are completely avoidable. For instance, if you're reaching out to someone, then it makes a difference if you first build a slight equation with them before bombarding them with your request for help. Because at the end of the day, a lot of persons will think, what is in it for me? Of course, at some points of time, altruism plays its part, but to expect each and everyone to be altruistic when you bombard them with a request is, I don't think, the way to go about it. So you need to invest time in building working relationships before you can seek to leverage those equations to your benefit.
Great. So I think we are nearing the end of the 1 hour time limit, but we have got a lot of questions actually from our viewers. So we'll take a few of those questions. So
Sure.
one question we have from Pankaj Tyagi. He's asking, "Sir, I am interested in criminal litigation at trial courts, but I don't have any backup to enter into litigation." I'm not sure what he means by a backup to enter into litigation. So, how should a law graduate approach getting a decent money during litigation? Okay. I mean, I think we have taken this question, we addressed this to an extent. Would you like to add anything?
I would just say that it really depends on the place you wish to begin work at. If, for instance, you're at one of the bigger towns, such as Delhi or Bombay, then there are different forums for you to choose to begin work. If you're at Delhi, you have the luxury of choosing from six different trial courts in Delhi. If you're at another big city, perhaps you have that benefit. But if you're from, say, a slightly smaller city, then those benefits may not be available to you. So it just makes a difference if you're regular at a place on a sustained basis of time. Because a lot of your work, you'll be surprised, comes with regularity of appearances and regularity of practice.
I think I have noticed a lot of young lawyers do well faster when they deal with tribunals rather than courts. Uh, do you have any observation on this? Especially new tribunals which just got set up. Like, for example, right now we have RERA or NCLT is relatively still a lot of new matters in the NCLTs around the country. So, do you have any comments on that?
Well, I guess it really depends on the kind of comfort you have in a particular branch of law. If a certain young graduate feels that they're more equipped to deal with a tribunal which specializes in, say, real estate or, for that matter, corporate commercial laws, and they get a foothold into it, then great for them. But I don't really feel that you can put a finger on it and say that as a young graduate you should focus on X or you should focus on Y. It's really a feature of your independent and individual comfort with a particular tribunal. For instance, if I were to go to a tribunal, it takes me a few seconds or a few minutes before I feel at ease at that place. But there are people who just take to it like a uh, like a complete natural, and that works great for them. I'm not one of them, so I don't think I can really advise people on that too much.
It's Would you advise practicing in a trial court or a high court initially? What are the disadvantages of practicing in the high court directly without practicing in the trial court? Being asked by Mohan Chandran. I think we have answered these questions in details already. Mohan, how essential or significant is knowledge of psychology for a criminal lawyer? Okay, so do you think knowledge of psychology can help a criminal lawyer?
Well, I guess it can help you be a little empathetic for sure. And if your psychology transcends to the power of judge reading, then definitely it helps. But as apart from that, I don't really know how psychology would translate into genuinely elevating your practice to a different level. So I think that there are certain amounts of emotional advantages which you can derive if you have a benefit of reading psychology at your undergrad level or on a postgraduate level, but I don't know if it actually or actively translates into practical benefits at the bar.
Okay, so that brings us to the end of all the questions. And so before we let you go, Shivam sir, why don't you tell us about something? If, let's say if there are people who are interested in practicing at the Supreme Court or interested in being uh, at the uh, practicing practicing criminal law, even at whatever level. What can you tell them to inspire them because they have a challenging task before them? What can you tell them to tide through those challenges?
Well, I guess my only piece of advice would be that please start reading the Bare Acts as often as you can, because you'd be surprised as to how much you'd come to learn each time you read the section. For instance, each time I read section 299 and section 300 of the IPC, it still takes me a little while to understand that what are the differences between culpable homicide amounting to murder and culpable homicide not amounting to murder. So there is a huge amount of benefit which is derived just from reading. The second piece of advice which I would offer is that whenever court begins, whether it be 10:30, 10, 11, depending on which place you are at, please make sure you're in court at the time it begins, because the amount you will learn just by observing other people mention matters and observing how judges react to mentioning the important words, the important keywords which you can pick up. Those are things which are extremely valuable. So, punctuality has its own benefits, which translate into a lot of advantages going forward. You'll save a lot of time and effort downstream if you know how to mention matters, and that comes by being in court right at the beginning when courts convene.
Okay, I have got another question. This came through message to me personally, and somebody requested me to ask you this question. Do you still? We know that we are very active on LinkedIn, but besides that, do you still get time to write articles or publish or like what you are advising, despite your busy schedule? And how do you go about reinventing your yeah, whether you've already done your masters and you've been to the Harvard and all of that, but besides that, how do you keep your enthusiasm and learning and development still alive for yourself?
Well, I think I'm not able to write as much as I was able to write even say 2 years ago, because work has increased and I have not been able to put out substantial amount of time to devote it to writing. Having said that, I still do write, and I write on issues which I feel are topically relevant to my core areas of practice. For instance, I have a specialization in sports law, and anything and everything which relates to sports law tends to interest me. For instance, if someone saw the match yesterday between Serbia and Switzerland, the two goals which were scored by Switzerland were people who were of Kosovan descent and Albanian descent, and the celebrations they made were celebrations that had political overtones. So that is something which ties up with my previous authorship on the aspects of sports and politics, and I think I'm going to develop more on it in the near future. So it takes a little bit of self-discipline to get into the habit, but I think the more you write, the more you're equipped to advance new arguments in court, or even older arguments with a greater deal of polish and finesse.
Great. Thank you so much. I think that brings us to the end of this session. So thank you so much, Shivam sir, for coming and sharing your best insights on an hour with LawSikho. And this was the last session this week. Everybody, thank you so much for following us and watching this session as well. And do subscribe if you haven't already to the YouTube channel so that you can keep getting the new ones from the next week onwards. Every week on weekdays we are having an hour with LawSikho from 8 to 9 in the evening, and on Saturday we have it from 4 to 5 p.m. Thank you so much for joining us, everybody, and thank you, sir. It was really a great pleasure to host you on an hour with LawSikho.
Thank you so much. It's my pleasure to be here. Thank you for the opportunity.
Have a great weekend, everybody.